Good morning, Judge. How are
I went
you?
on time parking. I didn't want y'all to think I was making y'all late.
I already told them. I put it in the Zoom.
All right, tell me, we ready on position one?
Judge, myself, you, and Mr. Abadi need to have a discussion.
Okay, you want to go into a breakout room? Adam?
Judge.
Hey,
Adam, Craig, and
let's go
Matt.
into a breakout room.
All right, see you there.
All right.
Oh yeah, I see. Adam, he made it. Okay.
All right, Miss Woods. Miss Woods. We got everybody back? Miss Woods? I don't see Max. Max is there. April?
Could we just let LaRon into the meeting if we're gonna talk about rescheduling?
Well, we can't find our fearless leader.
She was here not too
Oh, I
long.
guess, can you hear,
Oh, okay.
can you hear me now?
We can
Yeah.
hear you. We want to reschedule this ASAP. How long you need, Adam? 2 weeks to try to get your investigator out there?
That's more than enough time. Yes, sir.
Okay, let's go 2 weeks.
Okay, 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 now that's that's it. You want to do it on the 25th or the 26th? I think the
Yeah, I don't-
25th.
25th.
25th would be good. I think we have
Let's
some.
put your client in, Mr. Anderson.
Mr. Anderson, are you here? Can we see you, please, sir?
Mr. Anderson, turn on your video.
All right, Mr. Anderson, we're going to bring the victim's family in and have a thorough discussion of this case on the 25th of June. So you need to coordinate with Mr. Shard about how that's going to play out, okay?
Wait a minute, he can't hear you, Judge. He's still trying to connect to audio. Mr. Anderson?
All right.
Okay, ask to unmute. Hold on.
He's on mute, it looks like.
He is. I'm trying to unmute him now. There we go.
I'm muted. Hello? Hello?
Good
All right,
morning,
we're
Mr.
gonna have
Anderson.
this case come back on the 25th of June where we can have the
Matt?
victim's family. Can
You
you
say
hear me?
what now?
This
Yes, I'm
case is
listening.
gonna
What-
come back the 25th of June.
Okay.
You need to coordinate with Mr. Sharp
Uh-huh.
about how that's gonna work, okay?
Okay.
All right, we'll come back then. Adam, that's okay with you?
Yes, yes, Your Honor. Of
Is
course.
that all you have today, Adam?
Yes, sir.
All right, good to see you. You're
All
out
right.
and Mr. Anderson can be out. Y'all have a good day.
Yes,
All
sir.
right,
You
you
too.
All
too.
right. You do the same.
All right, Ms. Woods,
Yes, Judge.
please tell us.
We're on
what doing.
position, we are on position 2,
Ricky Burke?
State of Georgia versus Chanterelle Smith, actually.
Okay, that's Miss Paul.
That is not Miss Paul. I'm not, that is Mr.
I'm handling
Sharp.
that. I'm handling that.
And her presence is waived.
Yes.
Okay.
This is probation revocation, right?
It is, ma'am.
Okay.
All right, let me start here. Max, have you discussed today's proceeding with your client?
Yes, Your Honor.
Does your
Numerous
client
times.
Does your client fully understand that she would be appearing via Zoom and not be present in the courtroom, but you've waived her presence, right?
Well, I told her that she probably would not even be appearing via Zoom because she was in the jail and she wanted to complete this probation revocation as soon as possible. What I instructed her is if we're unable to connect her via Zoom, I would handle the court proceedings for her. And if she was suddenly released from the jail, it's not an error. I, in fact, took care of her probation revocation warrant and that she would need to contact me and probation to determine if she's still on probation and ask for further instructions as far as reporting.
So you waived her presence to be in this courtroom and you waived her presence to appear by Zoom.
Yes, Your Honor.
And you did that on the phone?
I did. She's called numerous times.
Okay, please proceed, Ms. Chenault.
Yes, Judge, thank you. I believe Miss Smith picked up a new case in another county. My recommendation was just to revoke the amount of time that she has already spent in jail. And I believe Madam Probation, Ms. Clark agreed with that, but Ms. Clark, I will let her speak to that herself. And Ms. Woods, when you get a chance, can you let us know how many days Ms. Smith has served in jail, please?
All right. Good morning, Ms. Clark.
Good morning, how are you?
Hey, I hope you're well. Thank you. Please start by telling us, is this the case number, the probation case number? It's already on the record. 17 case number. Okay. Tell me, please, what she was on probation for.
She was on probation for aggravated assault and possession of a firearm during a crime.
And do you know how much time, excuse me, do you know how much time she has left?
She was on first offender status and her remaining time is 2 years and 15 days.
Ms. Woods?
Judge, she's been in custody for 50 days.
What is the new case?
It's not here in Fulton County, Judge.
My understanding, and Ms. Clark, you can feel free to correct me. My understanding is it was a misdemeanor and she pled for time served.
I'm not sure of that. I don't have a disposition.
Do you know the case?
It was a disorderly conduct.
That's
Right.
what it was?
Yes,
All right. She waives notice, Max?
she does, Your Honor. And
All right, I'm
Ms.
gonna,
Clark, was
I'm-
she was sentenced as a first offender, correct?
That's correct.
All right, I'm gonna
Okay.
leave her on first offender and I will, she has 2 years, Ms. Clark.
Yes, 2 years, 15 days.
And so she's in the Fulton County Jail,
Yes.
Max?
Yes, Judge, she is.
50 days. All right, I'm gonna revoke and suspend. All right, thank you.
Okay.
And allow her to keep her first offender?
Yes, so ordered.
Thank you, Judge.
Thank you, Judge.
Judge,
right.
Okay. I'm going to bring in Ricky Burke. I'm sorry, guys. I was operating off the 1 p.m. calendar. Sorry about that, but we got that out the way.
So Ricky's there?
Yes, he's coming in now.
Oh, excellent.
Is this something that you and Ms. Chenault need to talk about offline?
No, we're in agreement.
Okay.
You got a
Is this
plea?
Yes.
is this negotiated?
I believe, yes.
Okay. Now we have to all be careful not to interrupt each other or talk over each other, or I'm gonna get in bad trouble with my court reporter.
That is correct.
That is, we'll
Mr.
take judicial notice of that.
Mr.
All right.
Burke, we need to see you. Wait a minute, Judge. Mr. Burke, we need to be able to see you. Can you do that for us? Mr. Sharp, you want to help,
Let me call
you
him
want to see
real
if you
quick.
can, you want to see if you can help him? Okay. Is Ms. Primovic, what do you have while we're waiting on Mr. Sharp?
She's muted.
She is, but she's coming back. Ms. Winfrey? I guess they're both muted.
Yes, I'm here. Good
Hey,
morning.
girl, what, do you have anything with Ms. Primovic?
No, I have one case is with Max. It's Mr. Colton.
Okay, I don't
Let's
think
do
he,
that next so Miss Winfrey can go.
well, Mr. Colton is not here yet, Judge, so we can't do that. Unless he's under somebody else's phone. I see Mr. Cotton, I see Miss Millender, I see somebody named Jaleesa. And the, Udo
Hold on
Chukwu.
one second. Miss Woods, I have Mr. Burke on the phone, so I'm gonna coach him through this real quick, okay?
Okay, thank you so much, Mr. Sharp. I'm gonna mute myself.
Ms. Woods, is Mr. Colton going to be on the call today?
He probably is. There are 4 people in the waiting room, Ms. Winfrey, and a couple of people, I don't know who they are. So they could be using somebody else's phone, somebody to know that knows how to navigate and use Zoom a little bit better. That's the challenge that we're having with Mr. Burke. But from my understanding,
Okay.
Mr. Colton is, unless there was an email that came through late last night or this morning. Yes.
Okay.
All right, thank you.
Good morning. You looking for Ham? He went out there. He may be back.
Good morning, Judge. You asked what I had today. I have afternoon court at 1, but I was just watching, making sure Max doesn't, keeping my eye on Max this morning.
I'm so glad we are live YouTube. This is just, we have 15 more days left.
I heard y'all were meeting with Judge.
Hey, Judge, we are live on YouTube.
Well, I'm not saying
So
anything
we'll have to
inappropriate.
talk offline. We'll have to talk offline.
Ms. Woods?
Thank
Ms.
you for
Woods?
checking on me, Judge.
All right, thanks.
Ms. Woods,
Yes.
could you kick Mr. Burke out and so he can reboot it? And while he's doing that, we could work on, we could do Brandon Cotton. Jaleesa
Okay.
is gonna be the mother of the victim in Brandon Cotton.
Who's the
And-
mother of the victim?
Jaleesa.
Okay, so I need to admit both of those. Okay.
All right, and I'm gonna have Mr. Burke work on getting back into the waiting room.
Okay, that's fine.
All right, thank you.
No, thank you. You said Cotton or Colton?
Cotton.
Let me put my glasses on.
I see you let Mr. Cotton in already, April.
What you say?
I see you let Mr. Cotton in already. He needs to turn his video on. Mr.
Okay,
Cotton,
I need to. Okay, what case is that? Do I have that on? Let me put my glasses on. Maybe I'm
um,
overlooking it.
no, he's not on the calendar. I believe he's a write-in. I can.
Okay. Oh, okay. All right. That's fine. Do you have the indictment number?
Yeah, let me get 1 second. It is 19 SC 172620.
Thank you.
You're
And
welcome.
Mr. Start is his attorney?
Yes.
Okay.
Max is his attorney. He's on mute.
I think Mr.
What is he charged with?
Where's Mr. Shard?
I'm right here. I just had to get his file.
What's he
Okay.
charged with, Ms. Chenault?
He's charged with hindering a person making an emergency telephone call, simple battery family violence, and another simple battery family violence. He's also charged with robbery on the indictment, but the state has elected to drop the robbery, so he would just be proceeding on the misdemeanors.
And is the lady here, ma'am, right here? What is your name?
Yes, Jaleesa.
And how do you know Mr. Cotton?
He's my husband.
I'm sorry, Judge, can we swear her in?
Okay, everybody, Mr. Cotton, ma'am, please raise your right hands. Right here. Do you swear or affirm the testimony you give before this court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes,
You-
I do.
All right, let me say this first. Mr. Short, have you discussed today's proceedings with your client?
Yes, Your Honor.
Does your client fully understand that he would be appearing by Zoom and
He
not
does.
be physically present in the courtroom?
He does.
Did you obtain a waiver, whether verbal or written?
A verbal waiver.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes.
Mr. Cotton, have you discussed today's proceedings with your attorney?
Sir.
I'm sorry?
Yes, sir.
Has your attorney explained to you that you have a right to be physically present in the courtroom?
Yes, sir.
Do you waive your right to be physically present in the courtroom?
Yes, sir.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, sir.
Does the state waive an original signature on the indictment and authorize the court to sign on its behalf?
Yes, Your Honor.
All right, ma'am, how long have you and Mr. Cotton been married?
2 years.
Do y'all have any children?
Yes, sir.
You have children together?
Yes.
Are there any other minor children in the home?
Yes, there is.
How many children total are in the home?
5.
And what are the range of ages, please?
13, 11, 5, 2, and almost a year old.
All right, and so he's obviously out on bond. Is he living with you or y'all living together?
No, sir.
All right, so is the marriage over with?
No, sir.
Do you want to be married to him?
Yes.
Have you had problems in the past?
Yes, we have.
Is there any particular cause of those problems?
I'm sorry.
Is there anything that starts those problems? Is there anything that creates those problems?
Yes.
What is that?
The things that create our problems would be we have issues with communicating, other issues that in the past we have resolved, but we seeking counseling, so it's
Are you
progressing
in
and getting.
counseling, Mr. Cotton?
Yes, sir.
All right, is this a marriage that you want to work, sir?
Yes.
Is this a marriage you want to work, ma'am?
Yes, sir.
All right, so tell me about living arrangements. Are y'all gonna be back living together?
Yes, sir.
When is that gonna happen? It's not happening now, right?
It's gonna happen within the next couple of weeks.
All right, and that's what you want, Mr. Cotton?
Yes, sir.
And Ms. Chenault, we don't have a history of police involvement in the past?
No, we don't, Judge. I would just like to say for the record that the victims in this case are Miss Washington's 2 older children. Miss Jaleesa is not actually the victim in this case, Judge. But to my knowledge, there is no prior criminal involvement between these 2 parties. Mr. Cotton does have a prior conviction for a misdemeanor involving violence, however.
All right, you've got children that need both of y'all to be in a
Yes, sir.
happy, healthy family home. You understand that, ma'am?
Yes, sir, I do.
Understand that, Mr. Cotton?
Yes, sir.
And that's what both of you want?
Yes,
Yes.
absolutely.
And we're gonna do right going forward
Yes,
Yes.
sir. Yes.
and realize how important those precious children are?
Yes,
Yes.
sir.
All right, let's proceed with you've negotiated a plea, Mr. Sharp.
No, Judge, I'm gonna ask for something different than what the state's asking for.
Tell me, Ms. Chenault, what you're asking for, please.
Yes, Judge, we're asking for 12 months probation with the condition that the defendant complete anger management classes while he's on probation.
And
Actually-
Judge, let me just, this is a different sort of case than I think what the assumption is. What I think Miss Washington was trying to hint at without putting everyone's business out there is, I think that there was, and correct me if I'm wrong, Miss Washington, I think there was an issue of infidelity and some issues involving those sorts of things at the time. And so there was a breakup going on at the time of this incident. What happened was Mr. Cotton was going back to the marital home that they shared to collect his stuff because he was moving out / being kicked out. Miss Washington, to her credit, she regrets this to this day. And I think Miss Washington, I think it's fair to say, shares some responsibility in this. Brought her children into the situation. Those are her children, not biologically Brandon's children, but Brandon was acting as a parental influence on those children through their relationship. Miss Washington had the children, the two older children, stay at home when Brandon was supposed to be coming to get his stuff, and had the children basically videotape Brandon, quote unquote, to make sure he wasn't taking stuff that didn't belong to him. I think in reality, it was probably a tit for tat type situation that brought the children involved. There's video of the actual incident that I've shared with the state. The video basically shows the police report and the statements were overblown by the children. And I've talked to the son, and he acknowledges that. The son wrote a report and he accused Mr. Cotton of being intoxicated. He wasn't. He clearly wasn't in the video. It accused Mr. Cotton of doing things without context. The reality is Mr. Cotton very calmly showed up to collect his belongings and only his belongings. The children, who again, Mr. Cotton had some parental control over for years, were using the cell phones, or at least the cell phone that he bought the son, to tape him and just basically harassing him. Mr. Cotton kept looking at them, asking them to stop, was not acting boisterous. At some point, the video shows Mr. Cotton go out to the balcony, and the children kind of stand in the doorway of from the house to the balcony, and Mr. Cotton's coming back into the house. I presume either Mr. Cotton was going to get his stuff or trying to cool off because he was understandably frustrated by the situation. And you can tell that's where Mr. Cotton takes the phone of the older boy. After talking to the boy, it's clear to me that the phone was taken. Mr. Cotton said, basically, I'll give the phone back, but y'all stop videotaping me. He was annoyed. He gave the phone back. And then the two children, based on the instructions of their mother, started to follow him around the house again and videotape him. And at some point, Mr. Cotton had enough of it. He took the phone again that he purchased for the boy, who he was a parental influence over, and took it from him. Now, if this case went to trial, I'd be asking for a parental discipline as the step parent of this child. He was in his rights to take the child's phone that he bought for him under these circumstances. And really, this is a lot about nothing. I've talked to Mr. Cotton, and I told Mr. Cotton if he wants to push this to trial, that's fine with me. It's on video. There's nothing aggravating. What the real question is, when you watch the video, is why are the children taping Mr. Cotton when he's peacefully coming to get his stuff? That being said, Mr. Cotton is gainfully employed. He wants this to be over with so he can focus on his job. He wants to focus on his marriage. Miss Jaleesa has been in contact with me many times. Miss Washington wants to focus on their marriage. I've spoken to the son. The son, I was blown away, as often I am with talking to younger kids or young adults, about how mature he was, about how honest he was when he talked to me, about his insight into the situation. I think everyone acknowledges that two adults brought children into a situation that they didn't need to be a part of. And I just think that everyone needs to move on at this point. I don't think a probation is necessary. There's no history of abuse between Brandon and Jaleesa or Brandon and the children. And I just think everyone needs to move on. And that's where we are.
Pleading to,
Yeah, we're pleading to the misdemeanors.
how long was he in jail, Ms. Woods?
Hold on, Judge, my Odyssey's acting up. Give me just a. He was in for 12 days.
All right, I think an appropriate sentence is the time served. I believe that, I'm confident that all involved, especially after Max's conversation with the young adults, the children, that we're gonna be on the right track, and the court's conversation with both the husband and the wife. So let's proceed to misdemeanor 12 months community time served. Okay, you may proceed, Ms. Chenault.
Thank you, Judge. And Candace, can you clarify? I'm not sure if the defendant gave an affirmative answer as to whether he agreed to under oath. Okay, so let me just go over that.
Mr. Cotton, take yourself off of mute because you're about to be asked some questions. You need to answer out loud, okay?
Yes, sir.
Okay, Mr. Cotton, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
It's Brandon Tarnell Anthony Cotton, Sr.
Can you spell your middle name?
Tarnell, Tarnell, Anthony, Anthony.
And I believe, were you a senior when this case started?
Yes, ma'am.
You are, okay, just making sure. Okay, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't been given today?
No, ma'am.
How old are you?
31.
How far have you gone in school?
I have a bachelor's.
Are you able to read, write, understand English?
Yes, ma'am.
Do you understand that you're being charged with 3 misdemeanors? You're being charged with 2 counts of simple battery, family violence, and 1 count of hindering a person making a telephone call?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Shard, about all the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Did you all also talk about potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a reading of the indictment?
I didn't hear you. Voice went out.
Okay. Do you waive a formal reading of the indictment?
I'll answer that, Mr. Cotton. So waived.
Do you waive any and all defects in the indictment, including any with respect to your name?
We do.
Ms. Washington, do you mind going on mute, please? Thank you.
Okay.
Were you arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No.
We don't.
Has your attorney advised you as to the minimum and maximum sentence for each charge you're pleading to?
Yes.
Each charge is a misdemeanor and is punished, and they're all punishable up to 12 months in prison, in jail, actually. Do you understand that?
Yes, ma'am.
Do you understand that this is a non-negotiated plea of guilty?
Yes, ma'am.
That means that the state and the defense cannot come to an agreement as to your sentence in this case. You understand that?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law? Do you understand that this plea may be used in future convictions if you have any?
Yes, ma'am.
This plea may actually enhance any future sentences if you have any, is what I mean. You understand that?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a plea of guilty today? I didn't hear your response, I'm sorry. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to having the balance revoked? Did you respond, Mr. Cotton?
Yes, ma'am, I did. That's how I understand.
Okay, I didn't hear you. Thank you. Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Mr. Cotton, we need for you to respond. I'm looking at you and I don't see any response. I don't see anything coming out of your
I think
mouth.
he's frozen. I think he's frozen because he's not moving. Ms.
Okay.
Cotton, you still there?
He might have to come back in.
Miss Washington, if you have his number handy, can you just text him and tell him he needs to come back into the, I guess, reload his Zoom?
Okay.
Thank you. Can we go off the record? Ms. Woods?
We can go into the breakout room, Mr. Sharp.
Well, I don't need to talk to, I just wanted to ask, is Mr.
We're
Burke-
live. Do you need to text me or call me on my cell?
We can be live, that's fine.
Okay.
I'm just saying that Ms. Sanders doesn't need to take this down. Is Mr. Burke showing up in the waiting room?
Mr. Burke is here, Ms. Hamilton,
All right,
Mr.
awesome.
Martini, Ms. Millender, and Udo Chukwu.
Okay, I'm
So-
gonna call Mr. Colton while we're waiting on Mr. Cotton.
Mr. Cotton is here right now.
Okay, all right, cool.
Okay, Ms. Chenault, we're ready when you are.
Okay, do you understand that there may be other adverse or unfavorable consequences?
Yes, ma'am.
Okay, I'm here, but I have to nurse, so I'm just gonna go off video for a minute. Some negative consequences that you may experience as a result of your plea include the following rights may be impacted: the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. You understand these rights?
Yes, ma'am.
And you understand that they may be impacted by you pleading guilty today.
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act? Just checking. Do you understand that you waive any and all defenses, including with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Do you understand that you're giving up certain rights you would have had at a trial?
Yes, ma'am.
Those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right
Yes,
to
ma'am.
the counsel, the right to the presumption of innocence, the right to testify, the right to subpoena witnesses, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand these rights? Mr. Cotton? I think he's frozen again.
Ms. Washington, could you let him know he needs to get back in?
And,
Okay.
and just, Ms. Washington,
Ma'am,
can he go outside? Is it where he is? Is it not a good, signal in the place where he gets a better signal, or is he using Wi-Fi or using his?
Okay, looks like Mr. Cotton is back, so we'll just wait for Max.
I'm back.
Okay. So I'm just gonna read the last question to you again, Mr. Cotton, because I'm not sure at which point your phone went out. So I was going over the rights that you had, if you were going to trial, that you're giving up today by pleading guilty. So those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right to the assistance of counsel, the right to the presumption of innocence, the right to testify, the right to subpoena witnesses, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand these rights?
Yes, ma'am.
And you understand that you're giving them up by pleading guilty today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of 2 counts of simple battery, family violence, and hindering a person making an emergency call, and indictment number, I'll get the indictment number.
It's 19 SC 172620.
How do you plead to those charges, Mr. Cotton?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging whether this plea was voluntary?
Yes, ma'am.
Thank you. And we already went through the defendant's criminal history, but just to say it again, Mr. Cotton has no prior felony convictions and we already laid the factual basis for the plea. So I believe we're just ready for for Judge Schwall'S sentence.
May I say something? I don't know if I can.
You want to say something before the sentence is given, Ms. Washington?
Yes, ma'am.
Okay, you can. Do you want the judge to hear it?
Yes.
Okay, well, let's wait a minute then.
All right, we're ready. So you're gonna proceed with a factual basis, Ms. Chenault? Where'd she go?
Hi, Judge. I'm here. I'm just on off my video for a second. But yes, we did already give a factual basis prior to taking the plea, Judge.
All right, Mr. Cotton, do you understand the nature of the charges against you?
One
sir.
second, Judge. So I think Ms. Washington wanted to say something before you gave a sentence.
Yes, ma'am.
Yes, Judge. I feel like it was just an honest misstep, and I was, given considering to Brandon's job is going to be very hard with him providing for his family to continue his career as a chef. I don't know
But
if
I'm
maybe
giving him the benefit of the doubt. Go ahead. Go
yes, sir.
ahead.
Yes, sir. I understand. I just wanted to express that on my end, as far as him being a provider for our family, it's going to pretty much damage his job. So I don't know if we can kind of lighten up a little bit, or would you?
But I'm gonna
consider
sentence
that?
him to time served. So there is no probation. Is that what you want? Ms. Williams?
Sir, I just wanted to make sure it wasn't going to affect his job. That's all.
Well, he's pleading to what, Ms. Chenault? She's on mute. Ms. Chenault?
Sorry, Judge. I didn't know you were asking me a question. Yes, he's pleading to 3 misdemeanors, Judge, 2 counts of simple battery, family violence, and 1 count of hindering making an out.
What is your job, Mr. Cotton?
I work for Senior Living Corporation. I'm a director for the culinary department.
For retirement homes?
Yes, sir.
Here's what I told Mr. Cotton, Judge, is I'm not in charge of the hiring, obviously, of any senior living facility. What I will say is there's certain misdemeanors on Mr. Cotton's record already that did not prohibit him from getting this job, and these charges were pending when he obtained this job. So I told him that obviously I'm not involved in the hiring or retention decisions of this senior living center. But what I told him on paper, the only thing that's going to show differently is, it's going to show that the felony has been dismissed, and he pled to the misdemeanors, which if his job ran a background, they would already been aware of, and also certain misdemeanors that were on his record already. So I don't believe that this plea adds a new class of anything to his record that didn't already exist, is I guess what I'm saying. But of course, I couldn't make any promises about what his job would do.
You understand that, Mr. Cotton?
Yes, sir.
All right. I find the defendant's competent to enter the plea. I find the plea has been entered freely and voluntarily with full knowledge of all the rights that he has knowingly, intelligently, and voluntarily waived. I find that he's competent to enter the plea. I find there's a factual basis. I will accept the plea and sentence on the 3 misdemeanors, 12 months community to time serve on each to run concurrent. All right, I'm hoping for great things for your family, okay?
Yes, sir.
Ms. Williams? I said I'm hoping for great things for both of you and your family.
Thank you.
All right, good luck to you. All right, what's next, Ms. Woods?
I'm going to bring Mr. Burt back in. Are we ready for that? And Mr. Sharp, while I'm bringing him back in, is Mr. Colton, John Colton Jr. going to be joining us today?
You on mute, Max?
I just talked to him. He said he didn't get the invitation, but I'm showing I sent it, and he gave me his email again, and I sent it again. So I've been in contact with him. I'm just hoping he sees it in his email. He says he's ready to come join us if he sees in his email.
Text me his phone number, please, while we're handling Mr. Burke.
Okay.
Thank you.
All right.
Ms. Burke, a plea
Yes, Judge.
negotiated?
Yes.
All right,
We're
Mr.
just
Burke.
waiting for him to get connected, Judge.
Ms. Woods, I just texted it to you.
I got it, thanks.
Candace, are you on mute?
Okay, there we go, Mr. Burke. Great job. Thank you so much, Judge. We're ready now. We have Mr. Burke present. Mr. Burke, can you hear us?
Mr. Burke?
I can see
It
him.
looks like he can't hear us. Mr. Burke? He's not on mute. Can you hear us, sir?
Mr. Sharp, can you help him with that piece?
I'm going to
We're
try to.
almost there.
Yeah, I know. I'm wondering if he doesn't have the volume up on his phone. I'm
Okay.
trying to deal with that right now.
Okay, and I'm gonna call your other guy.
Oh, it says connecting to audio. Mr. Burke, do you hear us now?
He's on mute.
Mr. Burke, take yourself off mute.
You're on mute. You see the little red microphone with a line through it? You need to get rid of that. You're on mute, sir. We can't hear you. Can you hear us? If you can, nod your head. All right. You need to take this little red microphone off. There you go.
Can you hear me now?
We can now.
Oh,
All
okay. Golly, man.
All right. Mr. Burke,
Yes, sir.
Judge Schwall, I want you to please raise your right hand.
Yes, sir.
Do you swear or affirm the testimony you'll give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may lower your hand. Mr. Sharp, have you
Yes, sir.
discussed today's proceedings with your client, Mr. Ricky Burke?
I have.
Does your client fully understand that he is appearing by Zoom and will not be physically present in the courtroom?
He does.
Did you obtain a waiver, whether verbal or written?
Verbal, yes.
And how did you obtain that waiver?
We spoke on the phone.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
We do.
Mr. Burke, have you
Yes, sir.
discussed today's proceedings with your attorney?
Yes, we did.
Has your attorney explained to you that you have a right to be physically present in this courtroom?
Yes.
you waive your right to be physically present in the courtroom?
I mean, what does this mean? I mean, I can't be
Mr.
there.
Burt, Mr.
Yes,
Burt,
sir.
what Judge Schwall is asking you is, you have a right to be physically present in the courtroom to enter a plea, but you can also waive that right to enter a plea via Zoom, okay?
Okay, yeah.
And what he's asking
Yeah.
is, do you waive that right to be physically present, and do you want to proceed via Zoom?
Yes, I do.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes.
Does the state waive an original signature on the indictment and authorize the court to sign on its behalf?
Yes, Your Honor.
All right, we have a negotiated plea. Please proceed, Ms. Chenault.
Thank you, Judge. Please raise your right hand. Oh, I'm sorry, you were already sworn in. Mr. Burke, please state your true, correct, and legal name.
Ricky Burke.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't been given today?
No, ma'am.
How old are you?
56,
How far have you gone in school?
12th grade.
Did you graduate?
No, I didn't.
Are you able to read, write, and understand English?
Yes, I am.
Do you understand that you're being charged with theft by conversion?
Yes, I understand that.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Mr. Shard, about all the facts and circumstances known to you regarding the charge and this accusation?
Yes, I spoke with him.
Did you all also discuss potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
If he say we do, we should. I don't know.
It's up to you, Mr. Burke.
All right, Mr. Burke. Mr.
Yes,
Burke.
sir. Yes, sir.
What he's asking is, we've already discussed the case, and you've indicated that you wanted to enter a guilty plea. Now, of course,
Right.
I'm going to say more to the judge about your case before the judge sentences you. So I'm going to talk on your behalf, okay? But what Ms. Chenault is asking is, do you need to talk to me privately about anything before we go forward?
No, no, sir.
All right.
Thank you. Are you satisfied with your attorney's services?
Yes.
Do you waive a formal reading of the accusation?
So waived.
Yes, ma'am.
Thank you. Do you waive any and all defects in the accusation, including any with respect to your name?
We do.
Were you arrested on this charge, Mr. Burke?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No.
Has your attorney advised you as to the minimum and maximum sentence for the charge you're pleading to?
Yes.
Theft by conversion is punishable from 1 to 10 years based on the value of the car in this case. Do you understand that sentence?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
That means that the state will recommend to the court a sentence of 1 year to serve 30 days, commuted to time served with the balance on probation. You understand this sentence?
Yes, ma'am.
Ms. Chenault, my understanding of the agreement was 1 year to serve 30 days, commuted to time served. I didn't understand the probation component.
Okay, we can suspend the rest.
Okay.
Okay, we'll suspend the rest. No, I think we have to. I think we have to have a balance though, because the minimum is a year.
Suspended. It can be suspended.
Okay.
Mr. Burke, what the state, what we've been discussing is that the recommendation, and we agreed to it, was 1 year commuted to time served, or to serve 30 days commuted to time served, which is essentially saying that you've done the service time of your sentence with the balance suspended, which would mean you'd have a suspended sentence, which means no active probation. Okay?
Yes, sir.
Okay.
Do you understand that this court does not have to accept this recommendation, Mr. Burke?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on future convictions if you have any?
Yes, ma'am. Yes, ma'am. But there will be no more convictions. No more. No more.
Okay,
No, I ain't.
okay, I just have to tell you, and that goes for this jurisdiction as well as outside jurisdictions. You understand that?
None. Yes, ma'am. None. Period. I'm not gonna entertain none of else. No more stuff there. Period.
Okay. Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a plea of guilty today?
Yes, ma'am. I'm not on nothing though. I'm not on no paperwork.
Yeah, I was gonna say, I don't believe that Mr. Burke is on probation, but Ms. Clark, if you show something else, please let us know.
He's not active.
Thank you. Do you understand that if you're
The
not,
camera just.
I didn't hear you, Mr. Burke.
I didn't hear you.
Okay.
No, I didn't hear you what you said.
Okay, can you hear me now?
Yes, ma'am.
Okay. Do you understand that
I
if you're,
can.
okay. Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes, ma'am. But I'm a citizen.
Okay. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. You understand these rights?
Yes, ma'am.
And you understand that they may be impacted by you pleading guilty today?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Do you understand that you're giving up certain rights you would have had you gone to trial?
I didn't hear you. While the train was going by, Diddy, I didn't hear you.
Do you understand that you're giving up certain rights that you would have had at a trial?
Yes, ma'am.
Those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right to the assistance of counsel, the right to the presumption of innocence, the right to testify, the right to subpoena witnesses, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand these rights?
Yes, ma'am.
And you understand that you've given them up by pleading guilty today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, ma'am.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of theft by conversion? And let me get the indictment number. In indictment number
Missional, it's 19 SC 173882.
Thank you. How do you plead to the charge of theft by conversion in that indictment number?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging whether this plea was voluntary?
Yes, ma'am.
Thank you. And just to go over Mr. Burke's criminal history. Mr. Burke has 5 prior felony convictions. It is relatively old. He has convictions starting in 1994 and ending in 2011. The first conviction we have is for forgery out of DeKalb in 1994, an ag assault out of Fulton in 1996, a forgery out of Fulton in 2006, a possession of cocaine out of Fulton in 2007, and another ag assault out of Fulton in 2011. Had this case gone to trial, the state would have shown that on October 22nd of 2019, officers responded to a stolen car from Enterprise Rental off of Capitol Avenue. Upon arrival, the victim, Michael Spalding, that's Spaulding, who worked for Enterprise, advised officers that the defendant, Mr. Ricky Burke, had rented a 2018 Kia Soul on June 22nd of 2019 and failed to return the vehicle on August 2nd of 2019. Officers confirmed that the vehicle was stolen and notified Central Records to list the vehicle as stolen. On October 24th of 2019, officers were patrolling around Memorial Drive in Maynard Terrace, and they observed the stolen car at that location, and the defendant was driving the car. The defendant was pulled over. He admitted to renting the vehicle, and he was arrested and charged accordingly. Nothing further from the state.
Mr. Burks, just hang on, okay?
Okay.
All right, what is the negotiated sentence?
Yes,
Judge,
Judge.
Go ahead, Max.
Oh, just briefly, Judge, Mr. Burke is not eligible for first offender. Of course, if he was, we'd be requesting it. But Mr. Burke is a pretty solid, personable guy. He works for one of the carriage companies with the horse-drawn carriages downtown. So he's gainfully employed. That's what he does for a living. And he acknowledges that he kept this rental car beyond the time that the contract specified and did not make arrangements to make further payments. And he acknowledges that that was wrong. And we would accept that we would ask that you accept the negotiated plea of 1 year to serve 30 days commuted to the time he already served with the balance suspended.
He's pleading to a felony.
He is pleading to a felony. He has some felonies on his record already, but based on the nature of these charges and the argument that this is really more civil in nature, we would ask that you accept the recommended sentence.
Mr. Burke, do you understand the nature of the charges
Yes, sir.
against you, sir?
Yes, sir.
You understand all the rights you give up by entering this plea?
Yes, sir.
You're giving up all these rights freely and voluntarily.
Yes, sir.
Is counsel satisfied that your client is competent in understanding the plea is voluntary? He's knowingly, intelligently, and willingly waiving his rights, and that he's competent and there is a factual basis?
Yes, Your Honor.
I find the defendant's competent in the plea. I find there is a factual basis. I find that it's freely and voluntarily entered with full knowledge of all the rights that he's waiving. I will accept the plea and sentence as enunciated by the state, agreed to by Mr. Sharp, and further enlightened upon us by Mr. Sharp as the order of the court. Good luck to you, Mr. Burke.
Thank you, sir, very much.
All right, thank you.
Mr. Burke, if you have questions, just give me a call in a couple hours, okay?
Yes, sir.
All right.
Thank you guys very much.
Take
You're
care,
welcome. Have a good day, sir. I believe I have Mr. Colton. We're gonna see if this is Mr. Colton. It's labeled as JPO.
Mr. Burke, you may leave if you wish.
Okay, thank you very much, sir.
Yes, sir. You have to hit leave meeting. You have to hit leave at your bottom of your screen.
Okay,
Should say leave. There you go. All right, who is this now?
Judge, this should be the state of Georgia versus John Alvin Colton Jr. Just need to verify this is a new person that's online. I contacted him and we were able to get him here. So let's just see if this is Mr. Colton. In the waiting room, we have Mr. Millender, Mr. Martini, Ms. Hamilton, and Udo Chuko. Mr. Colton? Mr. Colton? What's your name, sir? Hello? In the white t-shirt and the white hat?
That looks like Mr. Colton. With Mr. Burke, it took a second for the audio to connect after the video, so that might be what's going on. There we go. Now it's connected.
Okay. Okay. Wow, takes that long. He's using his phone, so I don't want to call him or send him another message, Mr. Sharp.
No, I hear you. I think it's best that we're just patient. Hopefully this works.
Because it looks like he needs to go out and come back in.
Said we have Millender.
Oh, he's connected.
Oh, okay, there we go.
Mr. Colton, unmute yourself. Unmute yourself.
Okay,
All right, can you hear
All
us?
right.
I can hear.
All right, so Mr. Colton, good morning. I'm Judge Schwall. Please raise your right hand. You swear or affirm the testimony you'll give before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I swear, I do.
Now, you may lower your hand. Mr. Sharp, have you discussed today's proceeding with your client, Mr. Colton?
I have.
Does your client fully understand that he would be appearing via Zoom and not be present in the courtroom?
He does.
Did you obtain a waiver, whether verbal or written?
It was verbal over the phone.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
We do.
Mr. Colton, have you discussed today's proceedings with your attorney, Mr. Maxwell Sharp?
Not fully represented, no.
Okay, Mr. Colton.
Yeah,
All right, we have discussed what's going to happen today, correct?
we just discussed the proceedings, yes.
Okay, well, Mr. Colton, the judge isn't about to just make a decision. I'm going to talk and represent you and advocate for you in the rest, okay? This isn't the end of the proceedings, okay? But the judge just wants to know if we discussed the fact that you are scheduled for a plea today, that you would not be appearing in person, but would be appearing via Zoom, okay?
Yes.
I'm going to talk on your behalf, but we're just not there yet,
Okay,
okay?
okay.
You waive your right to be physically present in the courtroom.
I do.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes.
Does the state waive an original signature on the indictment and authorize the court to sign on his behalf?
Yes, Judge. Good afternoon.
Good afternoon. All right. Is this a negotiated plea?
I don't believe so, Judge.
All right, it's a failure to register case. Can you tell me a little bit about it, please, Ms. Winfrey?
Yes, Judge. Mr. Colton was required to register as a sex offender for previous child molestation and a sexual battery on April the 25th, 2019.
You're on mute, Ms. Winfrey.
Yes.
Sorry, on April the 25th, 2019, officers went out to do a verification address. They went out to 1589 Olympian Way Southwest, Atlanta, to verify that the defendant was present. He lived there. He was not lived there, yielded a negative result for him living at that residence, which was the registered address that the sheriffs had for him. As a result, officers did issue the arrest warrant for him for this case, and he was subsequently charged for violation of the sex offender registry requirements.
So, I'm sorry, Ms. Winfrey, are you done?
Go ahead, Max.
Is Ms. Winfrey, are you finished?
With the facts, yes.
Okay. Judge, just Mr. Colton acknowledges that he was not in compliance. The backstory here is the incident that he was on registry for was from 2007. My understanding, and I reserve the right to be corrected by Ms. Winfrey, but my understanding is, generally speaking, he's done a decent job of registering. In 2007, in 2019, him and his brother, who is actually also on the registry, I believe, were living in this house. It was basically, from my understanding, an abandoned house. At the time of this incident, they were legally forced to move out of the residence. So he was functionally homeless, using that residence for registry. He was no longer able to use that residence, so he moved out and moved to another residence. And shortly before this visit, so he acknowledges that he did move, but there were some mitigating circumstances, obviously, financial, socioeconomic circumstances. He acknowledges that he should have updated his address, but also since his arrest, he did update his address. He is now in compliance. So he's taken those remedial measures to get back in compliance. And it was just a situation where he didn't have a stable address and failed to update.
Max, what is the record address now, please?
Mr. Colton, could you answer that, please?
I am a homeless. I have registered with the sheriff. I'm homeless still, and on the bridge, MLK in Westlake, and I've been in compliance ever since. I've not missed a meeting with the sheriff in any given time. I have reported every single time when I had to go. Whether
How
I
long
was
was he in jail, Ms. Woods? Ms. Woods?
I believe he was in jail for what?
7 days.
Oh, 7 days.
No, 1 day.
Sounds
I'm
like-
looking at the one. 1 day. Sorry.
It sounds like to me, he's trying to do the right thing. So let's do a plea to time serve upon the condition that he continue to register and be in compliance.
Now, Judge, I would like to state and put on the record, the defendant's criminal history in the terms of the court making this recommendation. The state's only concern is that he has approximately 2, 3, 4, at least 6 violations of probation already. The cases that he's required to register, one's out of Fulton County, the child molestation in 05 SC 37977, and then the sexual battery out of DeKalb County, which is 07 CR 5023. And after that, he's violated probation a few times. So our recommendation is that he would have some probation on this particular case. Although we're not recommending any time served in jail, we are recommending probation in this case.
Is Ms. Clark, is he on probation right now still for those other charges?
No, he is not.
Okay.
All right, my problem with the probation is that if he's homeless, it's gonna be hard to comply.
Well, here's a situation. You have a sex offender registry requirement, and the public needs to be aware. That's the reason why we have the statute.
All right, well, let's do this. Let's make a condition that he's probated with let's do 3 years probation, no reporting requirement as long as he's in compliance and reports to the sheriff his proper address. No
And
other
that's
requirements of probation. No reporting, nothing, as long as he complies. Can we
But
live
he
with
still has, I'm sorry, but he still has to make sure he goes to the registry, follow those reporting requirements.
Absolutely.
Okay, I want to make sure he understands that.
Absolutely. You understand that, sir?
Yes, sir.
All right, let's proceed
Yeah.
with the plea.
Judge, you would waive, obviously, he's homeless. He works as a painter, but obviously he's not doing well financially. You would waive all fees and fines associated with probation as well.
I will, and it seems to me that he's trying to do the right thing. Okay, and I'm gonna give him some credit for that. Okay, Mr. Colton?
Yes, did she
Mr.
mention
Cole,
those,
does that sound like,
those violation of probation they throwed out of court because it was bogus, all of them?
All right, well, let's proceed with the plea.
Mr. Colton, do you wish to proceed with
Yes.
the plea?
I do.
Okay.
Mr. Colton, you've already been sworn in. This is 19 SC 172181, where you're charged with 1 count of state sex offender registry violation. Will you please state your true, correct, and legal name?
My true correct legal name is John Alvin Colton Jr.
Okay. And Mr. Colton, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I am not.
I'm sorry?
I am not. No,
And is there a medication that you normally take that you've not been given today?
I don't take any medication.
Okay. How old are you and how far did you
I'm
go?
not on- I am 49 years old. I'll be 50 in August.
Okay. And how far did you go in school?
I graduated from 12th grade.
Are you able to read, write, and understand the English language?
I am, yes.
And do you understand that you are charged with the state sex offender registry violation in this indictment, which is 19 SC 172181? Do you understand that?
Yes, ma'am.
And do you understand that you have a right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
And excuse me. Have you had enough time to speak with your lawyer, Mr. Sharp, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
And do you need more time
have.
to discuss this case with your attorney?
No,
And are you satisfied with his services?
I am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. Colton, have you been arrested on these charges?
Ma'am,
Have you been
have
arrested
I been arrested? When?
on this charge?
He was arrested. Mr. Colton.
Again?
No. She's just asking the
Yes.
first time, were you arrested? Yes.
Yes, I have. I have been.
Okay, the reason why the state asks is that we are unaware of any outstanding warrants that are related to this charge. Do you or your attorney know of any outstanding warrants that are related to this charge?
We don't.
No, ma'am.
Has Mr. Stride advised you of the minimum and maximum sentence or minimum maximum range for punishment in this particular charge?
Yes.
Okay, for purposes of the record, the minimum for state sex offender registry in your particular case is 1 year, maximum is 30 years. Do you understand that?
Yes, ma'am.
Right. And do you understand that this is a non-negotiated plea, which means the state will make a recommendation to the court. The court has already actually put on the record what what the court is going to do in this particular case. The state recommends 5 years probation, but the court is already ruled that he will do 3 years probation in this case. Do you understand that?
Yes.
Okay.
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
And do you understand that this
I
plea may
understand.
be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in federal courts?
Yes.
And do you understand that if you are placed on probation of any kind, which you will be in this particular case, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
And do you understand that you are not allowed to use or possess a firearm while on probation?
I understand. Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And this is true regardless of any advice given to you by your attorney or anyone else.
Yes.
And do you understand that there may be other adverse or unfavorable consequences as a result of your entering a guilty plea today, just as there would be following a conviction after a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am. Understand.
You understand? Okay. And do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by pleading guilty today?
Yes.
And do you
Yes.
understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and to not incriminate yourself? Do you understand you're giving up those rights?
Yes.
And do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you with a court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted after this charge after a trial. Do you understand you're giving up those rights?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea today?
No.
So is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Okay. So how do you plead to the charge of state sex offender registry violation in indictment number 19 SC 172181.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you have only 4 years from today to file what's called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes. Yes.
The judge. Okay. 1 second.
Are we ready?
Yes, and Judge, we just want to perfect the record as to the facts. Again, Mr. Colton was required to register prior to, for violation of, required to register because of the conviction for child molestation out of Fulton County, out of DeKalb County, indictment number 07 CR 5023, which he's required to register. He did not update his address from 1589 Olympian Way Southwest in Atlanta in Fulton County. He was required to report to the Sheriff's Office in Fulton County to update that address. He failed to do so in violation of the sex offender registry requirement. And again, we state that the state will request that Mr. Colton be placed at least on 5 years probation. I know the court has already ruled, but I just wanted to place those things on the record.
Mr. Colton, do you understand the nature of the charges against you?
I do.
Do you understand all the rights you give up by entering this plea?
Yes.
And you're giving up all those rights freely and voluntarily?
Yes.
Is counsel
Yes.
satisfied that your client is competent in understanding the plea is voluntary and there is a factual basis?
Yes, Your Honor.
I find the defendant's competent in the plea. I find that it's freely and voluntarily entered. I will accept the plea and sentence to 3 years probation. The only term of the probation is that he comply with the sexual offender registry and report to the sheriff's department and have an address in compliance. And I understand at the time and now that he's homeless and I believe that Mr. Colton's trying to do the right thing. And so I'm going to give you the benefit of the doubt. I'll waive all fines and fees. And the only condition of the probation is that he comply.
And
no reporting.
okay, Judge, your recommendation is no reporting, correct?
No reporting. Just that he comply with the sex offender registry.
Judge, if I may put on the record, I was just told by our sex offender supervisor that it needs to state that he has no reporting to probation in order for him not to be required to report.
He's got to do what?
It has to state in the sentence that he does not have to report.
So ordered. That is part of the order. Okay. All right. Thank you.
Ms. Clark, you still need to get information from Mr. Colton, correct?
Yes.
Okay, I'm going to put you all in a breakout room. Mr. Colton, good luck. As soon as I can find out where you are, you're going to be in break room number 2. Mr. Sharp, you can't go along, Mr. Sharp, but we're okay.
But let me just explain, Mr. Colton, what Ms. Woods is saying is that she sent out a breakout room, which is going to send you an invitation to join the breakout room, and you're going to be in there with the probation officer.
He's already gone.
See,
He did good. Go ahead, Ms. Clark.
Oh, okay. He went in the breakout room.
Mm-hmm.
All right, awesome.
Wait a minute. Wait a minute. He came back.
Mr. Colton,
He's
go in
gone.
the breakout room 1 with the probation officer so you can talk about your address and the paperwork.
Is he gone? Yeah, he's gone. Okay.
Is he
And
in
we're
breakout
moving.
one?
He
Yes,
is in
ma'am.
the breakout room. Thank you, Ms. Winfrey. Have a good day.
Thank you, Ms. Winfrey.
Thank you. Have a good
Thank
day.
you for your patience.
Of course.
All right.
What's next?
Bridget Millender, position 4. That's with Ms. Chenault. Okay, she's back.
What are we doing there, Ms. Chenault?
Yes, Judge, this is a I think it's non-negotiated. The state is asking for 5 years to serve 30 days. And I believe Mr. Shard is asking for something else.
Mr. Sharp?
I'm going to ask for something. Yes, I'm going to ask for something much less than that. Well, hold on. Let's just wait until Miss Millender is connected.
Is Ms. Hamilton a part of this case?
The victim's name is Asia Moody. We've been trying to get her to log on, but she hasn't been responding to us today. We have talked to her in the past, though.
Okay, are there any other victims that might be in the waiting room that I need to know about?
I think go ahead. Go ahead,
What
Matt.
defendants do we have that are left?
We have Ms. Millender, who's trying to get logged in, Mr. Martini, and Ms. Perry.
Miss Perry, I instructed that she didn't need to call in because the state indicated that they were asking for.
Okay. Okay, all right, okay. Okay, so that leaves, because I see 2 people in here, I'm not sure who they are, other than Mr. Martini.
The victim for Mr. Martini is not calling in. He hasn't responded to our texts or calls. I believe we have a Justina Opala, but we're not, that's for jail.
Okay, maybe these people are for jail. So once we finish Ms. Millender and Mr. Martini, we'll find out. Do you want to message her, Mr. Sharp, to kind of see what's going on with her phone? 'Cause she's been waiting for such a long time.
Okay. Okay.
Mr. Sharp, we can move forward with Mr. Martini while you're trying to find Bridget, or give me her number. Okay, he's got her on the phone. Yes.
I don't, I think
Well,
she's, all right, I'm gonna text you, her number.
All right, I'm bringing in Mr. Martini, and you text me her number.
Okay, I don't think Mr. Martini is a, Kiana, where are we with, well, let's just wait for Mr. Martini, I guess.
Okay, he's got her on the phone. Mr. Martini,
Yes, ma'am. Can you hear me?
can we see you? There we go. Thank you so much, sir. You look wonderful. Thank you. Do you all need to go in the
Thank you.
breakout room, Mr. Sharp?
I need to hear from the state about what their plan is on this.
Okay. All right. We can't hear you, Ms. Chenault.
Thank you. I said we have not heard back from the victim despite our attempts to contact her and her mother. So we're going to proceed with PTI for Mr. Martini. I guess we can do virtual PTI, Max.
Okay, could, Ms. Woods, could you just set a breakout room for my, oh, there's Miss Millender. All right, excellent. Could we just set a breakout room for myself and Kiana and Antonio real quick? Miss Woods?
Yes, I'm working.
Okay, I just want to make sure you were there.
Yeah, I'm sitting up here trying to see. And Mr.
Antonio, we're gonna go into the breakout room when she sets the invitation, okay?
I
Gotcha.
thought I did. He did. I need to put you in there, Max, don't I? No, you're in there. Max, Kiana. Okay, yeah. Max, you don't have it. Everybody has it but you.
I don't have, okay, here we go. I got it.
Oh, okay. All righty. Miss Millender, we'll be with you in just a second, okay? All right, stay close to the phone.
All right.
Okay. So Mr. Martini is going to be a PTI offer.
I didn't hear you clearly, Ms. Chenault.
All right, we got a PTI here, Mr. Short.
Yeah, yes, Judge. Mr. Martini's going to do an online, it's going to be virtual PTI. He's going to do an online anger management class. He says it's going to be done in the next 5 days or so. He's going to email me the receipt of completion. I'm going to give it to Ms. Chenault, and we're going to get this case closed out.
All right, Mr. Martini,
Yes, Your Honor.
Ms. Chenault's giving you a good break here, okay?
Yes, sir.
And let's learn from this and let's move on in a positive, great way, okay?
Yes, sir.
All right, I have to ask you some questions and your lawyer some questions. Can you raise your right hand, please? Do you swear or affirm the testimony you'll give for this court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
You may lower your hand, sir. You may lower your hand. All right. Let me talk to your lawyer first. Mr. Short, have you discussed today's proceedings with your client?
Yes, Your Honor.
Does your client fully understand that he's appearing by Zoom and will not be physically present in the courtroom?
He does. I don't know if he's actually even waiving any rights because we're not.
No, I just want to talk about this hearing.
Yeah, he understands.
All right. And he waives his appearance in court?
Yes. Yes, Judge.
And you waive an original signature on the indictment?
We're not, I don't
All right,
think
we're not signing it. All right. You've discussed today's proceedings with your attorney, sir?
Yes, sir.
And your attorney explained to you have a right to be physically present in this courtroom?
Yes, Your Honor.
And you're waiving your right to be physically present in the courtroom?
Yes, Your Honor.
All right, well, you're going to communicate with Mr. Short, who's going to communicate with Ms. Chenault, and hopefully this case will be resolved within 5 days, okay?
Yes, sir.
All right, you may leave the meeting. What about Ms. Millender? Are we ready on that?
I am.
The state is ready, Judge.
Okay, is that a negotiated plea?
Judge, this is the case we started on where the state said they were asking for 5 years to serve 30 days followed by probation. And I was just going to state that we are asking for something much less than that. And we have our reasons for asking for that. I don't know if you want to do the plea in reverse.
Let's do it in reverse. Tell me the alleged facts, please, Ms. Chenault, and tell me your reasoning, please.
Yes, Your Honor. As to indictment number 18 SC 160141, the state versus Bridget Millender, as alleged on November 14th of 2017, an officer responded to an address in Fulton County, Georgia, in regards to a person being injured. When the officer arrived, he met with the victim, Miss Asia Moody, that's Moody, who stated that she was struck in the face with a hammer by the defendant, Miss Bridget Millender. The victim stated that her and the defendant were involved in a physical altercation. And during that altercation is when the defendant struck her. There was a witness on the scene, Miss Deadrienne, DeAdrienne, Miss Deadrienne Wright, who was there on the scene and confirmed the statements of the victim. The victim was also able to provide the license plate number of the defendant. The victim did say that she knew the defendant from a previous run-in. The victim did suffer a serious injury to her face. The state did provide the defense with pictures of those injuries, and the victim did have to get stitches to her face. And that's the reason for our recommendation, Judge. The defendant has no prior history, but just due to the type of injury and due to the type of assault, our recommendation is 5 years to serve 30 days.
Ms. Woods?
Judge?
Hey, how many days there's no record, how many days did the defendant serve in jail? Please.
Give me just a second. Ms. Millender. 18 days, Judge.
So Judge, here's the story. She was just recently arrested. There was a grand jury warrant out for her, which speaks to her ability to go through life without having police contacts. This case was initiated by the alleged victim as a private warrant. an officer did not take out a warrant for Miss Millender. The reality is the incident location, Miss Millender's married to a gentleman who I've spoken to on the phone that was not always faithful to Miss Millender. This alleged victim, Miss Moody, was someone who was having sexual relations with Miss Millender's husband. That led to, understandably, tension between Miss Millender and Miss Moody. Miss Moody came to the husband's aunt's house where Miss Millender was already, knowing that Miss Millender was there, and a confrontation ensued. I love the fact that Miss Moody has someone backing up her story, because that just proves that Miss Moody brought her girlfriends to come and gang up on Miss Millender while she was at her husband's aunt's house. Also, regarding the injuries, I've seen the injuries. Ms. Chenault has given me a picture of the injuries. I do not doubt that there were stitches. There was blood. It sure does not look like a hammer injury to me. It's not an injury that would come from a hammer. Miss Millender, if we were to go to trial, I would anticipate the evidence to show, and this would be through Miss Millender, her husband, and the potentially some people that are not necessarily inclined to come to court, but I would do my best to subpoena to make them come to court, would show that a group of women pulled up to the aunt's house, confronted Miss Millender. The alleged victim spit on Miss Millender. A fight ensued. Miss Millender had her keys in her hand and used her fist with the keys in it to punch Miss Moody, and that caused a laceration of Miss Moody's face, which, quite honestly, the pictures look a lot more like that scenario than someone hitting her in the head with a hammer, which would obviously cause much more damage, one would think. All that being said, I've explained to Miss Millender her rights to go to trial. I said that I've told her that this seems like something that could go to trial if she wishes for it to go to trial. But Miss Millender is hopeful that we can resolve this via a plea. She does not want a trial. She's not used to being in trouble, and the thought of going to a criminal trial is terrifying to her. And so she is eligible for first offender. I'm asking for first offender treatment. I'm asking, if probation is necessary at all, a 1-year probated sentence. There is some case law that suggests that probation is necessary for someone to receive first offender treatment. So, and I know that keeping her record is very important, clean record is very important to Miss Millender. So I guess in light of that, just explain why I'm asking for it. We'd ask for 1 year of probation. We'd ask that Your Honor consider waiving the fees and fines, and leave it in the court's discretion whether she needs to report to probation, but she's not a threat to reoffend.
How long was she in jail, Ms. Woods, please? Ms. Woods?
Sorry, Judge, I thought I was on. 18 days.
No record?
No, Judge.
All right, and so there were multiple individuals that came to the house where Miss Millender was, and it's your position, Mr. Sharp, they were coming looking for trouble and they found it.
That's my position. We know of 2 individuals because they've identified themselves, Miss Wright and Miss Moody. Our position is that there was more than just 2, in fact, and they came in the same car.
All right, I can do 2 years to serve 1 commuted time served, balanced, probated. Stay away from the victims. No further violent behavior, and I'll allow first offender.
And would you waive fees and fines associated with?
Yes.
Ms. Millender?
Hang on one second, Max. Ms. Chenault,
Yes, Judge.
did you have something you wanted to say?
No, Judge.
All right, Max, you're talking to Ms. Millender.
Ms. Millender, just take yourself off of mute. You got to hit the mic. There you go. Ms. Millender, the judge indicated, Judge, you broke up a little bit, but I think you said 2 years to serve one, commuted to the time she's already served, balance on probation.
No further contact with the victims. Now, are you still involved with your husband?
Yes, my husband is here. Yes.
Okay. Well, the allegation was that he was having an affair with the alleged victim in this case. You understand that?
Yes, sir.
All right. And you and your husband are going to be together, correct?
Yes, sir.
And I assume that he is going to stay away from the victim in this case, Miss
Asia Moody.
Moody. Is that correct?
Yes, sir.
Well, he's there. Is that correct, sir?
Stacy. 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 Stacy.
Uh-oh, Judge, look what you started.
Listen, we're peacekeepers here, Max. We're on YouTube. I do want to talk to y'all in a breakout room. I know y'all met with Judge Whitaker, didn't y'all?
Yes.
Yeah, I do want to talk to you. That's going to be a great.
Hey.
All right, sir.
We have jail calendar starting in 5 minutes, so we need to get finished with this.
All right, sir. The allegation is that you had a romantic interest in the alleged victim in this case, and your wife wants to continue a marriage with you, and she's going to stay away from this person. And I'm assuming that you want to continue the marriage with your wife and saw that the pain and strife this alleged relationship had on your marriage and your wife, and that you're going to stay away from this person. Is that correct, sir?
Yes, sir.
All right. Well, that's fine. Let me have your wife back on the screen, please. Thank you.
Thank you.
Yes, Your Honor.
All right, ma'am. I'm going to ask you to please raise your right hand, Miss Millender. Do you swear or affirm the testimony you give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You may lower your hand. I'm going to ask your lawyer some questions first. Mr. Sharp, have you discussed today's proceedings with your client, Ms. Millender?
I have.
Does your client fully understand that she would be appearing by Zoom and not be present in the courtroom?
She does.
Did you obtain a waiver, whether verbal or written?
It was a verbal waiver over the phone.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
We do.
Ms. Millender,
Yes,
have
Your
you
Honor.
discussed today's proceedings with your attorney?
Yes, Your Honor.
Has your attorney explained to you that you have a right to be physically present in the courtroom?
Yes, Your Honor.
Do you waive your right to be physically present in this courtroom today?
Yes, Your Honor.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, Your Honor.
Does the state waive an original signature on the indictment and authorize the court to sign on its behalf?
Yes, Your Honor.
All right, y'all may proceed to perfect the plea. Thank you.
Thank you, Judge. Ms. Millender, you've been sworn in already. Would you please state your true, correct, and legal name?
Bridget Monique Seaborn.
What was the last name you gave?
My marriage name,
Well, what is your legal name?
Bridget Monique Seaborn.
Okay, can you spell your middle name and last name, please?
MoniQue.
And your last name?
SEA. B as in boy, ORN.
Now, Miss Millender, you were born Millender or Seaborn?
I was born Millender.
Okay. And have you gotten married since this incident, or you were already married?
I was already married.
You were already Bridget Seaborn when this occurred?
Yes.
Okay.
Okay, so you never got your name legally changed to Millender?
No, my marriage name is Seaborn. I've been Seaborn for some years.
Okay.
I think it was just erroneously indicted as her maiden name. And Miss Millender, they indicted you as Bridget Millender. We are going to waive that defect in the indictment for the purposes of going forward with the plea. And we're waiving the defect in the fact that they indicted you as Bridget Millender, where legally you were Bridget Seaborn at the time, okay?
Okay.
All right, we could make them go re-indict it and everything else, but it would delay everything and we'd be right
Okay.
back to where we started. So do you wish to go forward with the plea waiving that defect?
Yes.
Okay.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't been given today?
No, ma'am.
How old are you?
39.
How far have you gone to school?
12.
Did you graduate?
No.
Are you able to read, write, and understand English?
Yes.
Do you understand that you're being charged with 1 count of aggravated assault?
Yes.
And I just want to make sure that's right. You're actually being charged with aggravated battery and aggravated assault, but those two would merge. So we'll just proceed with the aggravated battery and drop the aggravated assault. You understand that?
Okay. Thank you.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Mr. Shard, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Did you all also discuss potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes.
So waived. So waived.
And you already waived defects in the indictment, correct?
We did.
Were you arrested on these charges?
Yes, you were, Miss Millender. She was arrested on a grand jury warrant.
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
As long as that grand jury warrant has been cleared, there should not be any.
Has your attorney advised you as to the minimum and maximum sentence for the charge you're pleading to?
Yes.
Just to reiterate, aggravated battery is punishable from 1 to 20 years in prison. You understand this sentence?
Yes.
Do you understand that this is a non-negotiated plea of guilty?
Yes.
That means that the state and the defense cannot come to an agreement as to your sentence in this case. You understand this?
Yes, ma'am.
Are you aware of the state's offer of 5 years to serve 30 days?
What is that?
Miss Millender, that's the state's offer. The state's offer is 5 years to serve 30 days, okay? But we just had a discussion on the record where we discussed the case, and I anticipate that I'm going to ask for the judge to sentence you to 2 years to serve, what was it, 2 years to serve 1, commuted to the time you've already served, with the balance probated. So essentially, at the end of the day, it would be 1 year probation, okay?
Okay.
And we are asking for first offender treatment, and we're asking the judge to waive fees and fines associated with probation, okay?
Okay.
And the judge seemed inclined to do that. After the plea, you're going to talk to Ms. Clark, who's also on this call, and she's going to get your information for probation. But what she's going to tell you is if you do your 1 year of probation successfully, this case will not result in a conviction, and she'll talk to you about how you can get the record sealed as well. Okay?
Okay. Yes. Thank you.
Okay.
Okay, so I just had to put the state's offer on the record and make sure that you had discussed that offer with your attorney.
Okay. Thank you. Yes.
Do you understand that the court can impose any sentence authorized by law?
Yes.
Do you understand that this plea may be used to enhance sentencing on future convictions if you have any?
Yes.
And that goes for this jurisdiction as well as outside jurisdictions. Do you understand that?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a plea of guilty today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to having the balance revoked?
Yes.
Do you understand that you're not allowed to use or possess a firearm while you're on probation?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. You understand these rights?
Yes.
And you understand that they may be impacted by you pleading guilty today.
But if I completed in the first offenders, then that goes away.
I can't say for sure that it will go away. Having first offender does seal your record. So, theoretically, your rights are not supposed to be impacted. But for instance, you will still have the arrest on your record unless you try to get that expunged. So, employees may see that arrest that may impact your rights in some way. And I'll let Mr. Sharp speak.
Ms. Millender, the advantage of taking first offender is when you take first offender, it's not an adjudication of guilt, meaning if you file any application and they ask, have you been convicted of a felony? The answer would be no. And that would be a truthful answer unless your probation is revoked.
Okay.
All right. So you're pleading under first offender, which is not an adjudication of guilt. That's the bottom line. Okay. And if you do your probation as you're supposed to, it never will be. Okay.
Okay.
I'm just going to give Ms. Millender a minute.
Yes.
Okay. You ready, Ms. Millender?
Yes.
Do you have any more questions?
No, ma'am.
Okay. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty or no contest to or ever been convicted of a felony in the state of Georgia?
No, ma'am.
Have you ever pleaded guilty or no contest to or ever been convicted of a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Do you understand that you're giving up certain rights you would have had at a trial?
Yes, ma'am.
Those rights include the right to a trial by jury, the right to counsel, the right to remain silent, the right to confront witnesses.
Yes, ma'am.
I'm still going. Thank you. My computer got stuck. The right to the assistance of counsel, the right to confront witnesses, the right to remain silent, the right to a trial by jury, the right to testify, the right to present evidence, and the right to the presumption of innocence. You understand those rights?
Yes, ma'am.
And you understand that you've given them up by pleading guilty today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything in exchange for you pleading guilty today?
No, ma'am.
Do you understand that you waive any and all defenses, including with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Could we go back on that for a second?
Yeah.
Judge, Ms. Millender's asking that you accept this plea via as an offered plea.
That's fine.
Ms. Millender, what that means is you feel it's in your best legal interest to plead guilty, but you are not acknowledging guilt. So you acknowledge that there are pictures of this lady with Ms. Moody with severe or somewhat severe injuries, and you acknowledge that there's evidence that could lead to a conviction, but you're not acknowledging guilt because in your mind this was a self-defense case. Okay, so that's called an offered plea. Okay, so that's what we're asking the judge to accept. So you're not pleading guilty because you're guilty, but you're pleading guilty because you think it's in your best interest. Okay.
Okay.
Okay. So are you pleading guilty because you feel like it's in your best interest to plead guilty?
Yes.
Do you understand that this still counts as a guilty plea conviction even if you do not admit guilt?
Yes.
How do you plead to the charge of aggravated battery? And Max, can you read the indictment number, please?
It is 18 SC 160141.
How do you plead to the charge of aggravated battery in that indictment number, Ms. Bridget Millender?
You would say guilty under the offered case.
Guilty on the offer case.
There you go.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And thank you. Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
We have 1 year from today for a misdemeanor and 4 years from today for a felony to file a habeas corpus petition challenging whether this plea was voluntary. You understand that?
Yes, ma'am.
Thank you. And Judge, I believe we already provided a factual basis for this case, and Ms. Millender has no prior felony convictions.
All right. Do you understand the nature of the charges against you?
Yes. Yes.
You understand all the rights you give up by entering this plea?
Yes, Your Honor.
And you're entering this plea freely and voluntarily.
Yes, Your Honor.
And you're pleading guilty because you believe it's in your best interest to plead guilty.
Yes, Your Honor.
Is counsel satisfied that your client is competent in understanding that the plea is voluntary and that there is a factual basis?
Yes, Your Honor.
All right, I will accept the plea and sentence as previously discussed, and I will accept the first offender.
I'm sorry, Your Honor. I was on mute when you asked me that question about whether I thought there was a factual basis and thought. Well, could you repeat the last question, Ms. Sanders or?
Confident understanding that the plea is voluntary and there is a factual basis.
Yes, I do.
All right, I'll sentence as previously discussed, which I believe was 2 years to serve 1, commuted time served, balance probated. And the only condition of the probation is that she not violate the law, that she does not have to report, and she stay away from the victims and the incident location. Well, the incident location is her husband's aunt, right?
Yes,
Right.
but she moved from that house.
Okay, we'll stay away from the incident location. You don't have to stay away from his aunt. and I'll accept first offender. Good luck to you,
Would
ma'am.
you waive fees and fines,
I'll
Judge?
waive fees and fines, and I'll put on the record she doesn't have to report.
Thank
Now,
you, Judge.
we've been at this for a long time. We have most of
Judge,
the people.
hey, Judge, real quick, I need to move Ms. Clark and Ms. Millender to the breakout room. Secondly, the jails are already in the waiting room, waiting to go, one North Marietta and South, I believe.
All right, let's
So they're
break
all
for
ready to
about
go.
15 minutes to get a snack, and we'll come back at 1:30, okay? Thank you.
Thank you, Judge.
Judge.
I'm working on it. Hold on. Let's see. Stay right there, Miss. Okay, let me.
Well, actually, there's no one else here. I just need an address.
You can go. Okay, you could go ahead.
Okay, Miss Millender, or Miss Seaborn, I need your address, your current